The H1B guy here, and today the H1B guy is going to break down the two most popular employment-based visas available for non-immigrant status with dual intent in just 3 rounds. First off, I wanted to wish everyone an excellent Raksha Bandhan, and to everyone who celebrated Bakr Eid and Eid al-Adha over the weekend. Before we get to it, if you're not already, please subscribe to the H1B guy on YouTube. Now, let's get started. Round 1. H1B and L1B visas defined. H-1B, or what we refer to here on this channel as H1B, is a non-immigrant visa classification for someone who will perform a specialty occupation. It requires a specific number of years of experience and a bachelor's degree or higher in a specialty occupation or its equivalents. A bachelor's degree requires a minimum of 5 years of experience in the specialty occupation. And if you have a U.S. master's degree, it requires 3 years of relevant experience. The maximum period is 3 years or 36 months for the initial issue, and the maximum stay can be extended incrementally for up to 6 years or 72 months total. The filing fee will increase starting on October 2nd, 2020, as announced last Friday, and that new fee is going to cost $555 versus the L-1B, or L1B as we refer to on this channel, is a non-immigrant classification that enables a U.S. employer to transfer an employee with specialized knowledge relating to the organization's interests from one of its affiliated foreign offices to one of its offices in the United States. This classification also enables a foreign company that does not yet have an affiliated U.S. office to send a specialized knowledge employee to the United States to help establish one. The employer must file the I-129 petition for non-immigrant worker with the filing fee on behalf of the employee. Qualifications include that the employee must work for the qualifying organization abroad for one continuous year within 3 years immediately preceding admission to the United States. Seeking to enter the United States to provide services in a specialized knowledge capacity to a branch of the same employer or one of its qualifying organizations. Qualified employees entering the United States to establish a new office will be allowed a maximum stay of 1 year. All qualified employees will be allowed a maximum initial stay of 3 years or 36 months. For all L1B employees, requests for extensions of stay may be granted in increments of up to an additional 2 years or 24 months until the employee has reached the maximum limit of 5 years, 60 months total. A filing fee will also be increased for the L1 starting on October 2nd of 2020, and that new fee is going to cost $805. So just a really quick side note, we're not talking about the L1A visa today, but I do want to mention that the L1A visa is valid for up to 7 years, 74 months, but this only applies to individuals at the manager or executive level who hold the L1A designation. Both the H1B and L1B provide a direct path to non-immigrant status with valid work authorization in the U.S. Each has its own set of pros and cons, as we'll discuss. There are a few differences between the requirements of the two visas, and we'll highlight a few of them right here. The H-1B requires an employer to sponsor an individual through the annual HCap lottery, regardless of if they are working in or outside of the U.S., whereas the L-1B requires intra-company transfer and has no annual cap. H-1B visas are valid for up to 6 years, whereas L-1B visas are valid for up to 5 years. H-1B visas have less restrictions surrounding a change of employer filing versus the L-1B visa, which can be fairly restrictive when it comes to change of employer filings. The L1B visa will now cost more than $250 for the petitioner to file versus the H-1B visa. And finally, The L1B can be sponsored by a petitioner in the HCap fiscal year lottery. If awarded, any time worked in L1B status will count against the overall maximum validity if the H1B is awarded in the lottery. Round 2, path to permanent residency or green card. The H1B path to permanent residency includes employment-based perm labor filed by a sponsoring employer, a perm labor prevailing wage determination received from the Department of Labor. Individuals must possess minimum requirements depending on the employment-based category that the petitioner is filing in. Employer must run U.S. recruitment, validating no U.S. worker is qualified for the position advertised. Once perm labor is certified, a priority date is issued as the date in which USCIS received the employer's ETA form 9089 on your behalf. I-140 immigrant petition for alien workers. This is the second step of the green card process. And this is where a petition filed by an employer on behalf of an alien worker to become a permanent resident. It allows for an H-1B to be extended indefinitely until an adjustment of status is filed. The I-485 adjustment of status. Priority date becomes current upon the Department of State's monthly issued visa bulletin. The job offered in the I-140 immigrant petition for alien workers still exists with the employer that filed the I-140 on the beneficiary's behalf, and the beneficiary plans to accept the job once USCIS approves the beneficiary's I-485. If the I-140 was filed as a self-petitioner, the self-petitioner must plan to work in the same or similar occupation field as specified in the I-140. Versus the L1B path to permanent residency, which also includes employment-based perm labor filed by a sponsoring employee, a perm labor prevailing wage determination from the Department of Labor. The individual must possess minimum requirements depending on the employment-based category. The employer must run U.S. recruitment, validating no U.S. worker is qualified. And once the perm labor is certified, a priority date is issued as the date in which USCIS received the employer's ETA form 9089 on the beneficiary's behalf. The I-140 petition, immigrant petition for alien workers. This petition again is filed by the employer on behalf of the alien worker to become a permanent resident. Approved I-140 for L1B does not allow for indefinite extension. The I-485 adjustment of status, the priority date becomes current based upon the Department of State's monthly issued visa bulletin. And again, the job offer in the I-140 immigrant petition for alien workers still exists with the employer that filed the I-140 on the beneficiary's behalf, and the beneficiary plans to accept the job once USCIS approved the beneficiary's I-485. If the I-140 was filed as a self-petitioner, again, the self-petitioner must plan to work in the same or similar occupational field as specified in the I-140. So there are a few differences between the two visas on the path to permanent residency, and we're going to highlight a few of those right now. So first, while the L1B may provide the fastest path to permanent residency for individuals whose country of origin is deemed rest of the world, or the term you'll hear as ROW, it's no different for individuals from China or India, as they are still subject to the Department of State monthly visa bulletin. Even worse for L1B visa holders, they cannot extend their maximum stay under their L1B. So their options are fairly limited, and that is they can file for an EAD as an advanced parolee, or they must leave the U.S. for 1 year before applying for a new L1B. However, they do not lose their priority date or previously approved I-140 if the job offered is still the same as the one listed on their approved I-140. H-1B visa holders, however, can remain in the U.S. indefinitely under H-1B status, dependent upon having access to their I-140 approval notice. This allows the H-1B visa to be extended in 12 to 36 months increments until the priority date is current and the adjustment of status is filed. Round 3, H4 and L2 dependents, and we're also going to cover H4 EAD and L2 EAD. So H4 dependent, and this is a spouse of an H-1B visa holder, an unmarried minor under the age of 21. It does not possess valid work authorization. The H4 EAD is a spouse of an H1 visa holder with an approved I-140 that can file an I-765, which grants them work authorization with no restrictions. The validity period typically coincides with the spouse's H1B expiration versus the L2 dependent. Now, this is a spouse of an L1 visa holder or unmarried minor under the age of 21 and a non-immigrant classification, if approved, generally granted for the same period of stay as the L1B employee. The L2 EAD. This is the spouse of an L1B visa holder, an unmarried minor under the age of 21, and they may file an I-765 as well. Valid for up to 5 total years for the L1B, the L2 EAD is generally issued in 2-year increments as long as the L1B remains valid. So there's really only a couple of differences between the two dependent visas. The biggest is that the L2 may file for an L2 EAD before or after entering the U.S. and gain valid work authorization once their I-765 is approved with no restrictions. However, the H4 may only file for an H4 EAD after the H1B spouse possesses an approved I-140. And that's the second step of employment-based green card sponsorship, as we mentioned a little bit earlier. So let's break that down. The L2 dependents can begin seeking work before or after entering the U.S., whereas H4 dependents must wait until their spouse's employment-based green card sponsorship is past step 2, which can be anywhere between 8 to 14 months from when the perm labor process was initiated. As you can see, both the H1B and the L1B are non-immigrant visas that are also considered to be dual intent, meaning a path to permanent residency. These are highly popular in the STEM field as well as business, education, and health. Both provide path to permanent residency, albeit with completely separate approaches, and both offer their dependents work authorization, but it's directly tied to their spouse's status. After going through the verses here, I don't believe that there's really a clear victory in which one is better than the other, as they both have pros and cons. I wanted to also make one last very interesting data point. We talk about the popularity of these various work visas that are out there, with the H1 and the L1 being very popular. So for fiscal year 2019 and for fiscal year 2020, uscis hit the HCap lottery, which reached its limit of 85,000 new H1B visas. Okay. Whereas for fiscal year 2019 and fiscal year 2020, per the Department of State, in fiscal year 2019, 76,988 L1 visas were awarded. That includes both the L1a and L1B. And then for fiscal year 2020, we see a drastic decrease, and that's where 35,288 L1 visas were issued. So I wanted to ask you, were you aware of the difference between the H1B and the L1B visas? Have you worked under one or both, either H1B or L1B status? Did you have a preference? If you could, leave me a comment below and let me know which one that you preferred. So for the full post and more content like this, please check out the H1BGuy.com, where we have a list of education, news, opinion, and reform blogs that are posted there. And for more videos like this, please check out the H1B Guy channel. I just want to thank everyone for all of your support and taking time to watch my content. Just really, really appreciate it. It means a lot. As always, please like this video. Please subscribe to the H1B Guy and click the bell right there for notifications. The H1B Guy, your global source for all things H1B.